Morning. All right, I'm going to go ahead and start. My name is Ida Diaz, and I want just to welcome you to our presentation on as we work here on the, sorry, I'm getting a little throat here, the judicial, reframing the judicial system with early childhood court. So just before we get started, I want to go over some housekeeping details. If you look at the upper right-hand side, you'll see the word session, and there should be a blue line underneath it. That's for this session. And then you'll see the words chat, polls, people, and Q&A. Chat, as it says, you can chat here and type whatever you would like with the other members of the group. Our session does not have polls. If you click on, good morning, Kiki. If you click on people, you will also see the names of the participants in this session. Our moderator has asked that you save your questions to the end. So please, if you want to ask a question, click on Q&A, click on ask a question, and type your question in the box. You can also, if you don't want your name, just slide that over and ask anonymously. At this time, I'd like to introduce Dr. Emmy Graham.
Good morning. We're so happy to see you all in this session, and I'm happy to introduce our my beloved colleagues. We have Judge Latimore, who was one of the first early childhood court judges, and she has her court in the Orlando area in Circuit 9, and we just so admire all she brings to the bench, her trauma education, her compassion, and her zest and style. And we also have Leigh Merritt, who is from the Office of Court Improvement, and she's the heart and soul of early childhood court. She has put together the data system, which is so impressive. She has put together the whole early childhood court family and all the pieces, and they are here today to brag on and explain how Florida's early childhood courts are really transforming child welfare with trauma education and resilience and the whole science of hope. So without further ado, I'll turn it over to Leigh Merritt, who has the slides.
Hello, everyone. Thank you, Dr. Graham. I'm delighted to be here with you, and I'm so lucky to be able to work with Judge Latimore and Dr. Graham and so many other awesome professionals around the state. Thanks for having me. I really appreciate your inviting us to speak today. So let's just get started. Florida's early childhood courts. So, what is going on with babies and child welfare today? The big picture statistics, are that these young kids really are at risk. More than half of children under age 2 who come to the attention of child welfare because of either allegations of abuse or neglect are at high risk for developmental delays and neurological impairment. Infants and toddlers are the largest single group entering foster care. It's been that way for a long time, and spend the greatest amount of time in care once they're there. So they're mostly in foster care or with relatives, and some are still at home. Early childhood court really is a problem-solving court, like dependency drug court and some others. And you might be saying, well, what is the problem that's being solved? And the problem is that there are children, infants and toddlers, or young children in the child welfare system. Even one is too many, and that's the problem.
So good morning, everyone, and I'm so happy to be here as well to join Mimi, Dr. Graham, as well as Leigh. And we are always passionate to speak about early childhood court, and we are so happy that we were invited to present this this session on early childhood court. So the purpose of early childhood court is to allow us to heal the trauma and repair the parent-child relationship or bond and attachment as most people know it, for children who are between the ages of 0 and 5. It is a problem-solving court because we know that many families that come to the dependency arena come with a host of issues and problems that need to be resolved, other than just the fact that they have somehow found themselves before a juvenile judge to deal with the removal of the child from the home. But there are other matters that need to be addressed in order to promote timely permanency, to bring some healing to the family, not only to the child themselves because of the trauma they may have experienced as a result of witnessing domestic violence, living with a parent who has a substance abuse issue or substance use disorder, or living with a parent who has a significant mental illness, but also the trauma that the parent brings with them, because we know that there is a cycle of abuse and neglect. And we want to really address those issues that underlie the family in order so that we can repair that and possibly break that intergenerational cycle that these families tend to experience. So early childhood court was going to go straight to the source. We're going to provide services and give treatment to deal with trauma and to work on the attachment and bond that the parent and the child has. This has been shown through the research and the data to promote timely permanency. We always know we're up against that timeline that says that children should reach permanency within a 12-month period. But we also want to make sure that when these children are reunified with their parents, or if they're placed with a different caregiver, that we don't see them come back to our system for being either removed again or having experienced another episode of abuse, neglect, or violence.
Okay. And this lovely slide is obviously a picture of our map. So you can see all the different early childhood court judges around the state and then the counties that they preside in. So these are the rock stars that we feel early childhood court judges and magistrates around the state. And I just wanted to give you a little bit of history while we're on the slide. So I could give you a long story about how we planned this thoughtfully and everything, but honestly, it started with Dr. Graham coming to us at the Office of Court Improvement and saying, I think this is something that we can do in Florida. And she was very familiar with the Safe Babies Court Team, the national approach. She's also familiar with the Miami Child Wellbeing Model and has done a lot of work with young children, of course, over the years as an expert in child development, et cetera. So she came to us and we looked at each other and said, this is something we can do in court improvement as a court improvement activity. So when I tell people it just started like with an idea on a napkin, that's kind of how it did start, in her office one day back in early 2013. So we went to work, and after much groundwork with lots of different people taking control, not me for sure, not just me, but lots and lots of people, ECC started to take off. And in 2015 is when we had our first really kickoff meeting where we gathered all the parties around the state. Some people had a baby court, they called it back then. Some people didn't. Some people wanted to. Some people were anxious about it. And we came together, judges, magistrates, and these small court teams to talk about how we could start that. And actually right now we're in the middle of our fourth kickoff type meeting. So there's a lot of different conversations going on now versus what was happening back then. But we've served 1,240 children so far since the beginning. Back in 2014 when we started collecting data, we really usually have about 365, 70 or so children at any given time with active ECC cases going on. But I think it is quite impressive, and I'm pretty proud that we have been able to serve as many children as we have. So just to get another idea, it's 1,240 children have gone through the doors of early childhood court and of the steps of the courthouse since the beginning. And at some point, maybe we'll go out of business, and that would be my goal. All right.
So I'm with you on that, Leigh.
Okay. I wish I could see your face, but so I'm glad you invited us. And I know that one of the focuses that you have is evidence-based interventions and best practices. And so ECC is exactly that. grounded in science and best practices. And Dr. Graham can talk about this much better than I. But early childhood court, like Judge Latimore was saying, early childhood court judges and court teams know that the most rapid development occurs in the first 5 years of life. They're educated on this. Early childhood development principles are used in this court every day, keeping timely permanency in mind. When I say timely permanency, what I mean is for permanency is a legal term we use in dependency court. That means children have a permanent home. Either they're reunified with their parents, they're adopted, or they're permanently placed with a relative or a non-relative. And when I say timely, I mean that the federal timelines say that we must strive to achieve permanency for all dependent children within 12 months. So we're keeping the timely permanency in mind at all times and utilizing the best possible early childhood development services as quickly as we can. So the teams understand that toxic stress and abuse disrupt healthy brain development. And this time is really crucial to these children's success and well-being and how they succeed in life. So the judges and court teams recognize the value of stable, healthy attachment relationships, like Judge Latimore was mentioning, and ensure that the placement decisions are made wisely while keeping this in mind. And the team supports parents in addressing their own childhood trauma histories, again, like Judge Latimore mentioned, and strengthening healthy relationships is very important. Obviously, we want to help them develop the resilience that they need to go forward with any future challenges, and so we do not see them again in early childhood court. Child-parent psychotherapy is something we'll talk more about in just a minute. Helps to heal those generations and break that cycle of intergenerational cycle of maltreatment.
So just to kind of give you an idea of the difference of early childhood court compared to our traditional dependency court, I'd like to just discuss some of the core components that have led to this model and really make a difference in how these children and families are able to heal and also achieve permanency for the child after going through the process. If you have had any contact with the dependency court, you may recognize it to be sometimes a very adversarial process where a lot of attention is given to making sure that parents comply with certain tasks that they're required to do as part of what's called a case plan. Once the family is before the court, parents are ordered to receive and attend certain types of treatment in order to address what is believed to be the cause of bringing the family to the dependency child welfare system. Often in traditional dependency court, there's a lot of focus on the parents and their compliance. And then we have attorneys who represent the state as well as representing the parents and a guardian ad litem for the child. Typically, there are hearings that are scheduled either 3 months down the road or 6 months, what we call judicial reviews, in order to have the parents and the families come back before the court to advise the court as to how the parents are progressing on their case plan. And there have been, as many of you may know if you're familiar, instances or many cases where children remain in limbo, not having reached permanency or reunification with their parents or a permanent placement with another caregiver for an extended period of time. That was the real concern about the welfare of children who are not able to have a permanent or forever family for months or even years. And that has been proven not to be in the child's best interest. So with early childhood court, we have a completely different approach. And I can tell you that we call Dr. Graham the mother of Florida childhood court. She has been such an amazing figure in regards to changing the child welfare system and how we, in fact, help our children and families in this arena. And once I met Dr. Graham and had an opportunity to learn about early childhood court, I've always said that I drank the Kool-Aid and I've been hooked ever since. Because I realized after practicing for 15 years as an attorney or guardian ad litem in dependency prior to my joining the bench, which now I've been on the bench for 15 years also. I realized that when we were in traditional dependency court, we were missing something. We were not doing things right. We were having children come back to the courtroom, coming back after being abused again or removed. And so something was missing. And early childhood court, I believe, has absolutely figured it out. In these cases, we have what's called a multidisciplinary collaborative team, where we have a team of experts and a team of stakeholders who work together in order to address the issues that the family and the child are facing and to ensure that they have proper treatment and proper services in place. This team is non-adversarial, and the proceedings are non-adversarial. Can you imagine going to court and attorneys aren't fighting against each other? I mean, that is just an amazing concept in itself. The whole team is comprised of not only the community coordinator, which I'll speak about more in a moment, but also case management, the guardian ad litem, the attorneys for the parents themselves, the caregivers. Anyone who really touches this family is considered a part of the team. And the purpose of the team is to be there for support, to have trust and confidence that they are there to assist the family and the child with all the necessary services that they need. But one other key component or partner in the team is a child parent psychotherapist. And that is really our premier treatment that is offered in early childhood court. We have this mental health specialist who specializes in infant mental health in order to work with the parents and the child, in order to work on their relationship, to heal their bond and their attachment, to help the parent to recognize the cues that the child may give that are related to trauma and stress that the child may be experiencing. Many people say, how can you have therapy for a child who's between 0 and 5? Well, children can express stress and distress and trauma. They have certain cues. And the main point of the child parent psychotherapy is to work with the parent or the caregiver if the parent cannot be reunified with that child, in order to recognize the language of the child and to help that child to heal, because we want to make sure that we are providing healthy remedies for the children so that they can become whole. As we mentioned before, between the ages of 0 and 5, that is the most important time for brain development in children. And therefore, we want to make sure that we are addressing the issues that need to be considered. Our community coordinator is the one that position that oversees all of the functions of early childhood court. They also will be the one who conducts what we call family team meetings. Family team meetings brings everyone together on the team, other than the judge, to come together and sit down and really talk about what the parents or what the child may need in an informal setting. So it's kind of like, putting everyone at the dining room table in the family and saying, what do we need to do in order to make sure we address all the issues for the child and all the issues that need to be addressed for the parent. That could be as significant as asking that assessments be done to determine whether the child needs additional services such as occupational therapy or physical therapy or speech therapy. Or that might be as simple as the parent does not have sufficient transportation. So maybe we can offer them bus passes in order to get to court or to get to their CPP therapy or other types of counseling and services that they need to meet. So the community coordinator is what I call the glue of early childhood court. And we want to make sure that the community coordinator has everyone in place. And she or he is also responsible for reaching out into the community, to have community partners to make sure that if we have any gaps in services, that we will be able to receive and acquire those services for our children and family. And so the main core components that we really like to highlight for early childhood court is that we have this multidisciplinary team that's working together for the sake of the children and families. And they are overseen by a community coordinator who is the liaison between the team and the court and the judge, who's able to help connect them, since the judge is not able to be present for many of the sessions that are held with the family. And that we have CPP therapists with infant mental health concentration, as well as more frequent hearings. We see our families on a monthly basis, not on 3 months, not in 6 months. We see them monthly, which allows us to address any issues a lot quicker. With the judicial leadership that oversees this whole process, we're able to have much successful outcomes for our family.
Great.
Leigh, someone asked if you could make your screen larger. I don't know if everybody has the capacity to make their own screen larger, or if you do, or.
I don't.
Okay, all right.
Maybe Ada can assist.
Okay, maybe they can make their own screens larger. Okay.
Okay. All right. So the early core components led us to a way of our current best practice standards. And if you look at their screen, if you can make it larger, some of the core components are listed there. Judicial leadership, of course, is a core component for early childhood court. We have amazing judges and magistrates around the state who are overseeing our early childhood courts. Some are in one county, some handle several counties. And that leadership really does direct the team as to what needs to be done in order to ensure that we are providing a prompt services to our family, and we are addressing the needs of the child. Mainly the difference is that we keep a focus on the child. That's really what we're here to do, is to serve the child and make sure that we provide the services that are necessary. We often in traditional dependency court or non-ECC courts may lose focus. We get distracted on other issues. And really the issue and the focus that we need to have is on the child and addressing the issues with the trauma through our trauma lens, looking at what services and what needs this family may have, constantly focus on ensuring that we're addressing any trauma or potential trauma that may occur. As I mentioned before, our community coordinator, our child parent psychotherapists are all important components of early childhood court. One matter that I didn't discuss is concurrent planning. Concurrent planning is that although we may have the first plan is to reunify the children with a parent, that may not always be successful. But we also need to have a plan B. And so even at the beginning of the case, we start to think about what would be plan B if we're not able to successfully reunify the child with a parent. And that could be permanent guardianship or adoption. Whatever that plan is, and often at times it is adoption because we want real permanency for our children, we need to start talking about that in the beginning. Often in non-ECC cases, that isn't even discussed until we get to month 10 or month 11, after the parent has worked really hard and thinking that they may in fact be making some progress, but they ultimately are not able to substantially comply with their case plan and are suddenly looking at the permanency or the termination of their parental rights and the possible adoption of their child. Speaking about concurrent planning at the beginning of the case allows us to fully explain the process to our parents, and also it allows us to be transparent, to have them have full faith that we're not hiding something and suddenly going to pull something out of our back pocket at the end of the case. They fully know that if they are not able to successfully complete their case plan within a certain period of time, that they potentially will have their parental rights terminated or their child could be permanently placed with another caregiver. And we discussed that from the beginning of the case, and we discussed that concurrent planning throughout the case. And so we're fully transparent about the options that potentially are available for permanency for the child. And so we want to make sure that we continue to focus on having frequent contact with the family, frequent contact with the child, and oversight through our court process. But we've also learned that it is important that the parent and the child have as much contact as possible. And actually, our ideal case, or the ideal scenario, would be to have the parent have daily contact with their child. We want them to improve and to enhance their relationship and their attachment and bond with the child. And we've learned that frequent visitation and family time is key. We've also learned that when a parent has frequent time sharing with their child and they're able to develop that bond and relationship with their child, that they're highly likely to be successful with complying with the case plan task and ultimately being reunified with their child. So we've learned all these core components are important, and they are particularly necessary in order for our families to be successful in their cases. And with these core components, we were able to have the benefit, and we're so proud to be at the point where the Florida Supreme Court approved our best practice standards, which was based on these ECC core components. And we've able to make sure that we are targeting certain populations, because we recognize that there's a disparity and there's an equity issue in regards to how families are being treated for certain populations. There are certain disadvantaged groups that need this attention and definitely could use the services that we are offering for our families in early childhood court. It also addresses the responsibilities of our judges and our magistrates in these cases, how we should be conducting these hearings, how we should actually be interacting with our families, making sure that we timely address issues that come before the court in order to provide services. And most important, we make sure that we have what is our evidence-based therapeutic intervention through child-parent psychotherapy. It is the preferred intervention in our best practice standards, and it has been proven to be a key component of our court, our early childhood court. And so with that, we are happy to learn that we are having a success based on the data that we are receiving. In addition to the child-parent psychotherapy that's offered, we also offer other services such as substance use disorder treatment. As I mentioned before, occupational therapy, early childhood steps. Early Learning Coalition is often a partner with us in order to make sure we're providing educational opportunities for our children as well. And we have lower caseloads in our cases to make sure that we have enough the capacity to provide the necessary services and attention that we need to give to our family. So this court, I can talk about it all day long, and I'm sure Leigh is like, you need to move to the next slide, but I can absolutely explain in a full day. I think I could probably gather all of the benefits of having an early childhood court in our community. And I hope that one day this will become the norm.
It's great. You can tell she is really an advocate. We're so glad to have you, Judge Latimore. I am keeping an eye on time, however, and I do want to just go ahead to the next slide and just show you this really quickly. This is some results from an evaluation that was conducted for the national approach of Safe Babies court teams. And in fact, right now they're calling it Infant Toddler Court Program. So if you do look up 023.org, you can read more about this, but it basically shows the results from the evaluation that are positive, that children return home sooner or exit foster care sooner, and then there's a less occurrence of abuse or neglect. reoccurrence of abuse and neglect, which is exactly what we're seeing also in our analysis, which you can look at on our flcourts.org at www.flcourts.org website. And, next slide is, this just shows this shows from the California Evidence-Based Clearinghouse for Child Welfare that child parent psychotherapy is rated a 2, which is supported by research evidence. So just to show you that it is in fact evidence-based. And also, let's see, this is just a quick clip of child parent psychotherapy in action. It's a little bit older of a video, but still relevant. I want to make sure I showed you that.
How you look at his eyes. When I did first meet Jean and Kevin, she really didn't speak to Kevin very much.
Hey, Carrie. Do what I like it. Come on. Go play with it. Stop, Kevin. Stop it.
Jean didn't have that experience of a parent getting down on the floor and playing with her. And we really had to start from scratch. And that's been a treatment goal of ours, to add the eye contact, the communication, the language, reading his cues, nonverbal cues, and she has done an excellent job with that.
He just used to be by himself and play on by himself, so he'll never come to me. But now, yeah, play with me and yeah, talk to me more. Tell me what he wants. I guess he opened up too. It helped me just open up more because I'm usually to myself. I don't really talk to people. Because I was in foster care, and when you're in foster care, you just move from home to home, and you think no one loves you or anything.
There were reasons why we developed policies to keep moving people. We thought we were doing something good because we didn't want the children to develop attachments. We didn't realize is that the formation of the attachment is healing. It's critical for healthy brain development. And that's why our system of foster care that moves children from one home to another, as well intended as it might be, is actually the absolute wrong thing to do from a protection of the brain perspective. It's just adding one more stress to the child's life.
Okay. All right, thank you.
All right, so putting it all together is that, again, we're working as a team. And if you notice that we work with the judicial leadership, as I mentioned, to make sure that we have judges who are trauma informed, trauma educated, and trauma responsive. I'm always focusing on making sure that we are attending to the main issue. The problem that we have in problem solving court for early childhood court is that children are being removed from their parents. They're being placed in foster care and they're experiencing trauma. But they're not the only ones, as we know, who may have experienced trauma. We often have their parents who have a history of trauma themselves and therefore need to work through their trauma history. So we have a judge who has knowledge of that, who's been educated in all of that and able to preside over cases where we're dealing with these issues. We have our community partners who we reach out to help us to provide services, whether they are services that are therapeutic or services that are just simply material or practical. We have, for example, mustard seed, if our family needs furniture. We have other providers who will provide substance abuse or substance use disorder treatment, mental health and mental illness treatment. So our community providers really are key to how it is that we are able to help our families. And we could not do it without our community. We often have quarterly meetings inviting community partners to come and meet with us so that they can understand what our early childhood court is doing and how they can be helpful and be a partner and join in with helping the families in our community as they attempt to succeed and be a healthy family for their children. We help our caregivers. We make sure we have a focus on caregivers. As you've seen, we've learned that attachment is key. I mean, we've recognized that we really need to take the time to consider the effect of changing the placement of a child before doing that haphazardly. You may be familiar with the history of children in foster care being moved to several different foster care homes. Well, we understand that that is detrimental to children. And therefore, we don't want to do that without really finding that is necessary and in the best interest of the child. Previously, we didn't necessarily consider trauma and attachment before making those placement changes. Now we do focus on that. And so the joining of all the partners, we definitely are working together with the center focus being on the child. And that's where our focus should be.
Great. All right. Are you okay, Judge Latimore, if I just go to Judge Schustrom's clip?
Yes.
Okay. This is Judge Schustrom from the Second Judicial Circuit.
The trauma science is absolutely essential to a judge being able to decide that this resource that I'm deploying is something more than window dressing, that this resource that I'm deploying can actually be more than a hoop for these people to jump through, but instead an effective intervention that can restore a family, protect a child, mitigate trauma, and strengthen families ultimately.
Okay. Just a picture of all our judicial leaders.
A gathering of photos of many of the judges around the state, and you can see just in their expressions how committed our judges are and the joy that we find just being in court, and particularly the advantage we have with having our children come to the courtroom with us. That makes a big difference in being able to see them personally. I'm good with lollipop, so I'm known as the lollipop lady. So I'm always happy to see my kids run in to get a lollipop. Just want to make on the next slide, want to highlight how important it is that we work as a team. We're working with all of our partners, whether they be parents' attorneys, which were, previously known to be, advocating for their clients, but sometimes being adversarial and working to what we saw may have been against the whole process. And so now we're able to have our parents' attorneys join us as well. Case management and guardian ad litem and attorney ad litem are very key because they are there to focus and provide information to the court. All of this information coming from our team players and being provided to the judge is so invaluable when making the decisions that are key and important to our children's best interest, and ensuring that we are addressing the trauma that they have experienced, and giving our parents the tools to continue to address those issues, to pick up on their cues, to work on that bond and attachment so that we ultimately can achieve the ultimate goal of breaking intergenerational cycles so that our families do not continue to come back to us in later generations.
Great last words there. Okay. Ada, if you could help me to unshare my screen or stop sharing my screen.
Yeah, yes, just click stop sharing.
I don't know how to.
You can see that, or just, there you go. Yes, then I'll just close it. Should be able to do that, and it should say down at the bottom, stop sharing, or just click on the your screen down at the bottom where you see the little screen icon and click on that. There you go.
Oh, there we are.
We've had
For such a
That
yes.
that was excellent, Judge Latimore and Leigh, and we've had a very active chat going on. I don't see any questions in the question room. I think most of the questions have been in the chat. I don't know if anybody wants to unmute and actually ask a question, but they would be happy to take any of your questions. I think the main chat has been that, wow, these are very impressive components, and wouldn't it be great if we had the same kind of focus in family court, DV court, and explained and maybe Judge Latimore, you want to explain, you do the DV court, and so your trauma education has carried over into the other court. You want to talk about that a minute?
Absolutely. And I actually have had an opportunity of being a part of the education committee for the Florida Conference of Circuit Judges. And as part of our education program, we are making really big strides in ensuring that we are trauma training our judges across the board, regardless of whether they are in a juvenile dependency court or juvenile delinquency court division. Trauma is important for all of our families, regardless of what their legal issue may be, because as you know, problem solving courts, which I'm currently assigned to, we recognize that many families come to court for a variety of legal issues, but it's what's underneath all of that we really need to be addressing. What is the social issue that they're dealing with? What are the behavioral or family issues or experiences that that comes with the individual who's standing before us, even though they may be there for domestic violence, or even if they may be present for a family custody case. So we are absolutely making the efforts to try to educate and trauma train our judges, regardless of what their assignment is. We've recently just finished last week, in fact, partnering with an excellent team of judges who trained new judges, as well as judges being assigned to the domestic violence division for the first time. And were able to invite me. I was very privileged to have an opportunity to present trauma and ACEs to those judges, so that even though they're in domestic violence and they're often dealing with the violence that's occurring, they need to understand that violence that's happening in the home is causing trauma, and how that can affect not only the children who are part of those families, but also the parents who are sitting before them in court. So we are making sure that we try to spread this education and inform our judges on every level about the importance of being trauma trained.
That's great.
Great. And if people want to get involved, of course, there's the Guardian Ad Litem program where you can volunteer there. Are there other ways that folks can be involved? We need a lot more therapists. So if anybody would like to be trained in child parent psychotherapy, it's a very rewarding work. And of course, we need great people as case managers and judges and lawyers and, the whole team. So, and to continue to do your trauma education that all of you all are involved with. So, we've got miles to go before we sleep. So,
Dr. Graham,
yes.
I saw a question, if you don't mind. I saw not a question, but a statement in the chat, and I thought maybe you could kind of address it, if you don't mind.
Sure.
It reads, I am a therapist and have seen children regress after meeting with biological parent. Is this taken into consideration when allowing continued contact with biological parent? And I can tell you my perspective as a judge, but I really would like you to speak about how child parent psychotherapy addresses that and handles those type issues about how children may respond when meeting with their biological parent.
We had a judge just this week who said, The kid was 2 years old, had been with the same foster parent since 5 days old, and the bio parent finally got in recovery, and so they wanted to move the kid abruptly. And the judge said, it doesn't matter, all kids have trauma. It's like turning the TV off, they get trauma before they go to bed. All kids have trauma, it doesn't matter. In early childhood court, our judges, they don't, first of all, we don't have judges that abruptly move kids, and we have a team, and the child parent psychotherapist provides insight to the team based on working with the family. And if the child is regressing, we know that's a huge trauma sign, right? And so you would slow down, you would recommend to the judge to slow down the visitation cycle. And conversely, if they're doing well and thriving, you would increase the visitation. So we try to be very cognizant of what's happening with the child and don't have a cookie cutter plan, but rather individually look at how the kids are reacting to the visitation or the overnights or the transition. And what we know is that children attach. We want them to do that. And often they attach to the foster family, and while the bio family is getting their in recovery or whatever. And so transferring the attachment from whoever's been that main caregiver of the baby to the bio parent is often a process. And we need to follow the child's lead in that and not just have some arbitrary, they're going to start overnights, come hell or high water, regardless of how the baby is doing, because it is the transitions are very hard on young children, as you all know, particularly in developmental, like the stranger anxiety. The time from about 8 months to like 2 years of age is a really critical developmental period. So we could talk all day about that, but having a judge who appreciates the attachment science and recognizes the trauma, like Judge Latimore, really is the difference in night and day in early childhood court. That's why we want early childhood court for all children 0 to 5. And if any of you all have the opportunity to advocate within your community with your legislators, there's also some federal legislation, and we would love to have baby courts all over the country, and Florida is certainly the model. So thank you so much, Judge Latimore and Leigh, for inspiring us with your work, and hopefully all kids can have this. We have one more question. Are we done? Or
yes, I could go all morning with this session.
Okay.
And this has been amazing, 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 amazing. So I want to thank Dr. Graham. I want to thank Judge Latimore. Thank you, Leigh, for bringing this information to us. I started my career teaching preschool, and I know how important it is. And yes, it's so critical, this work, so critical. So I thank you again. We're on a break. So you have a break until 10 o'clock, and there's a survey that we would love for you to complete. And I encourage all of us to get into this work because it's so important for our future, It is so important. Thank you so much. I sincerely appreciate it.
Thank you all.
Day.
Thanks so much.
Abrazos, Kiki.